Okay.
Willie Cater. I'm so sorry.
On Wednesday, I received an email, or the court did, with the list of repairs.
How long you say?
Mr. Cater, hold on. Mr. Ruark, did you receive those?
I received it this morning, Your Honor. Actually, yesterday it was sent to me. I didn't see it until this morning. Most of them are routine repairs. We got a guy over there a week or so ago to address the repair issues and made many repairs. I would remind the court that for the last 2.5 years, this was not even an issue until into this eviction case before the first hearing.
Hi, Michael. I'm sorry about that in the court.
Okay.
I have a suggested resolution, Your Honor.
Go ahead.
Mr. Cater currently owes 6 months rent. That's $12,600. I would suggest for possession purposes only that we cut the rent to retain possession to $8,000. That would give him $4,000 to address some of these routine repair issues. But we had a guy in there that said the air conditioning system, the heating system is just fine, and so on and so forth. But that seems more than fair.
Mr. Cater?
Your Honor, I really don't want to get what Mr. Rourke is really talking about, because the AC and the heat repair is just fine. The issues that I'm discussing is the water that's coming out the drainage and the water that's always leaking in the walls, Your Honor. And that has been one of the main issues.
All right. Mr. Cater?
Yes, sir.
If you don't get what he's talking about, here's what he's talking about. Okay. They have you owing $12,600.
Yes, sir.
They're willing to cut 1/3 off of your rent and enter a judgment for that and give you a 1/3 abatement. I'm sure not admitting any liability, but they're willing to do that in terms of settlement.
Correct, Your Honor.
And,
Mr. Cater?
and if I do enter into this judgment, how long will I have to pay this $8,000?
We're asking 10 days, Your Honor, the statutory amount.
No, I'm not going to enter in.
Okay, here's what we're going to do then. Nope. Here's what we're going to do. 10? At what time? 9 a.m. I'm going to set this for non-jury trial, October 10th, 2023. What time? 9 a.m. At 9 a.m. That will be in person. Got to come down to the court.
Yes, sir. Oh, I can't hear now.
Your Honor, may I point out one other thing?
I can't hear. I couldn't hear nothing you just said at the end, Your Honor.
Okay, then let me just tell you.
Yes,
Can
sir.
you hear me now, Mr. Cater?
Yes, sir.
I just set this for non-jury trial, October 10th, 2023 at 9 a.m. in person at the courthouse.
Yes, sir.
Yes, Mr. Rourke.
One other thing, I checked with the court yesterday. The court had ordered Mr. Cater to pay, I believe, 1 month's rent into escrow. As of yesterday, that payment had not been made.
It wasn't 1 month.
That is correct.
It wasn't.
That is correct. That's why.
Yes, sir.
That's why I'm setting the immediate trial. Okay, I understand that. I saw that when I opened the file this morning.
Thank you, Your Honor.
All right, thank you. We'll see you guys on the 10th.
Thank you, Your
All
Honor.
right, thank you, Your Honor.
Court calls the case of Covington Apartments versus
our interrogatories and document requests to Mr. Johnson. So we'll just be waiting to hear back from him on those.
When did you send those to?
We sent it to his email address, and we also sent it via mail.
But when did you do that?
We sent that today.
Oh, you just sent them today. Okay.
And then we also plan on filing a motion shortly for lack of personal jurisdiction.
Leave it to these law students. Well, okay, what do you mean lack of personal jurisdiction?
Yes, we believe that we have a personal jurisdictional issue in today's case because the plaintiff asserts that he personally served a notice to quit to Ms. Walker on June 20th, 2023. But Ms. Walker has made it clear that other than like appearances in the court, she's not seen the plaintiff since January 25th of 2023. And if this is true, then it should establish that there's a lack of service and then a lack of personal jurisdiction.
Don't want to make a legal argument with you, but is it really personal jurisdiction?
It's supposed to be lack of service.
Yeah, I know, but you're saying there was no notice to quit. Is that really lack of personal jurisdiction?
Just lack of jurisdiction in general.
In general.
Right. Just lack of jurisdiction.
Nice save. It was like he was in the classroom and all of a sudden it's probably going to be lack of subject matter jurisdiction because he hasn't invoked the jurisdiction of the court, but that's okay. You'll figure it out. All right. How long will it take you to get that motion in? Maybe we can solve it right now. Mr. Johnson?
Yes.
It says that on June 20th, 2023, that you personally served on Miss Walker a notice to quit. Did you hand a notice to quit to her?
Yes.
You did?
The sheriffs gave it to her.
No. You signed, I'm not talking about the lawsuit itself. I'm talking about the notice to quit for non-payment of rent.
Yes.
You handed it to her?
No, I didn't hand it to her. It was mailed to her.
Well, hold on. Because we're going to have a problem here, Mr. Johnson. Because the proof of service on the notice to quit or demand for possession says that you delivered this to her personally.
I put it on the door at the house.
Okay, well, there's a problem also. Because now you told me that you handed it to her, but then you said, no, you mailed it. And now you're telling me you put it on the door.
All the stuff, because I knock on the door, she doesn't answer, and the people at the court told me to just put it on tape it onto the door.
Oh no,
So
don't blame the court. They didn't tell you that. Mr. Johnson.
Yes.
I need you in the camera.
I'm right here.
Raise your right hand.
Yeah.
You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
The demand for possession in this case, did you serve that on Miss Walker?
I put it on the door because she would not answer the door.
You put it on the door?
I taped
Meaning
it on
you
the door.
taped it to the door?
Yes, sir.
Pardon? Mr. Johnson. Mr. Johnson? Really? Mr. Johnson,
I'm here.
you put it on the door.
Yes.
You taped it to the door?
Yes, sir.
So why does your proof of service indicate that you delivered it to her personally to the person in possession.
I didn't say that. Who said that?
I'm looking right at it, Mr. Johnson. The box is checked. That you served a demand for possession personally to the person in possession.
Well, I must have checked the wrong box then, Your Honor.
Well, gee, Mr. Johnson, because there is not a box, Mr. Johnson.
But she never answered
There
the
is
door.
not a box for taping it to the door.
If she doesn't answer the door, I had to tape it to the door.
Okay, we've gotten past that. You told me you taped it to the door because she won't answer the door. Okay, I don't know if that's true or not, but assume it's true. What I'm telling you is that you represented to the court that you personally delivered it to her and signed it. And that's not true. That's point number one. Point number two is taping to the door the demand for possession is not a proper form of service of the demand for possession. You understand that, Mr. Johnson?
Yes, but the officer tried to give it to her too, and she wouldn't answer the door.
What officer? In this process for the demand for possession, there's not an officer involved. You signed a document that you submitted to the court indicating that you served on Ms. Walker this demand for possession on June 20th, 2023 by delivering it personally to the person in possession. That's what you signed. That's what you submitted to the court. And based upon what you just told me, that's false. And then even what you tell me is not proper service for the demand for possession. So here's the problem. And now, counsel, this is where you were going to go when you were going to type it on the paper, but just stay with me. In order to invoke the jurisdiction of this court for this type of proceeding, I have to have a proper notice. That proper notice must be served upon the person. By your testimony, I don't have a proper notice. Therefore, the subject matter jurisdiction of this court, since I'm a statutory court, has not been invoked. This case is dismissed. The court lacks subject matter jurisdiction. Thank you.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Young man, you understand what I just did?
Yes.
Okay, all right.
Thank you, Your Honor.
You're welcome.